Jack Smith extorted the defense team in the classified documents case. We know that the deranged thugs there have done much more than that. And now James Trusty, an ex-prosecutor and a former Trump attorney who was on the other side of the equation, who was receiving this abuse, this misconduct, and this assault on American justice, is now testifying in Congress. And we're going to go through and see what he said. He is going to explain the multiple problems with Jack Smith's assault. And if you forgot who he is, let's take a look at his bio. He, of course, very experienced individual, been around for 27 years as a prosecutor. He has done tons of cases, RICO, computer fraud, and says he can help you with your problems. Lots of credentials here. And we've heard him. He was also on the Trump team for a while before leaving. And you can see this beautiful attorney photo. Welcome to our law firm. We're going to solve your problems for you. How big are they? This big? We can handle it. It's great, action shot. Love it for attorneys. A lot of attorneys do that. I might have some myself. Who knows? But he was in Congress today and he was testifying. Remember, this is another attorney who also represented Trump on the classified documents case, Tim Parlatore, and his name comes out in this. But let's jump right into James Trusty testifying in front of Congress today, and his opening statement chronicles all of the abuse. Let's listen.
Thank you, Mr. Chair. My name is Jim Trusty. I've been an attorney for 35 years. I spent my first 20 as a local and federal prosecutor in Maryland, and in both roles I was fortunate enough to be involved in some fairly complex or weighty prosecutions. It starts with the usual of misdemeanors and routine felonies, but I was able to do a no-body child murder case as well as numerous RICO cases against MS-13, and I personally led 3 different death penalty prosecutions as a federal prosecutor. In 2011, I moved over to D.C., against my better judgment maybe, but I came over to the department to work at Main Justice with some other folks that I knew from Maryland and became the chief of the organized crime and gang section, which was a fascinating job that I enjoyed for about 6.5 years. I was able to manage a group of prosecutors that handled international, national, and regional organized crime cases against everything from MS-13 to Barrio Azteca, the mafia, and international white-collar conspiracies. And I was also, during this time, a senior member of the Attorney General's Death Penalty Review Committee, helping the Attorney General decide whether to pursue the death penalty against folks like the Boston Marathon bomber and the Charleston church shooter, among other numerous lower-profile cases. If my memory serves, I served under 7 different attorney generals. And in 2017, I left for IFRA Law, a boutique litigation shop, where I've represented everything from international gaming institutions to white-collar executives to human trafficking victims. And in 2022, for about a 1-year period, President Donald J. Trump.
Yep, 1 year
On
for
August
Trump.
8th of 2022, I became deeply involved in the Mar-a-Lago case involving President Trump, and I've given significant detail in the written statement, which I can't even begin to fully broach in a summary, but I'll try to hit some highlights. I wrote that statement. I took the time to write that statement because I think it's important for you and for the American people to have specific evidence, to have details to support the conclusion that the Department of Justice is acting in a weaponized fashion when it comes to a candidate for the presidency of the United States, that this is, in fact, lawfare in its rawest form.
Yep.
The Mar-a-Lago case is plagued with singular moments where prosecutors took incredibly aggressive and I would say prejudicial steps, the likes of which I had never seen in 35 years of practice on both sides of the aisle. The politicization actually began with the National Archives and Records Administration, whose director ended up making historic and first-time criminal referral based on his stated concern, his overstated concern, that he had received documents from President Trump that were in fact marked classified within 15 boxes given to him in January of 2022. The reality is every modern-day president has also turned over boxes or groups of materials that included documents marked classified. But in this case, NARA acted alarmed, and recent litigation in the Southern District of Florida has suggested that, in fact, the White House helped spur this referral on to the Department of Justice. Once in the hands of the Department of Justice, the lead prosecutor reportedly, according to the Washington Post, fought with the FBI to immediately jump to the perch of doing a criminal search warrant at Mar-a-Lago. He was talked out of that, apparently, in a heated conversation, and still relied on a criminal enforcement tool, which is a grand jury subpoena, to begin this process of gathering documents by force and by use of criminal sanction. For brevity's sake, I'm just going to highlight 3 examples of what I think are singular treatment of President Trump that I document in my written submission.
Let's go, Jim.
First is the abusive process in grand jury. And again, grand jury is usually fairly opaque to the defense side. We don't see everything that happens there, but we had some glimpses of the behavior, of the threats, of the conduct of prosecutors. And the one I would highlight today was the presentation of Tim Parlatore, a former Trump lawyer as well, friend of mine, who went into grand jury and was asked by the Department of Justice attorney, I think 48 times, I might be off by 2 or 3, but 48 times he was asked questions questions that clearly led to an invocation of attorney-client privilege. Those questions are unethical on their face. A prosecutor should not be in front of a grand jury purposefully eliciting a known privilege, but they were comfortable with this in this setting in Washington, D.C. that we were in.
And the court just let it go 48 times. No ramifications, no ethical complaints. Those prosecutors are not going to get sanctioned by the state bar. It's total madness, total lawlessness, and they can just get away with it. And it's during a grand jury, and those proceedings are locked down. They're secretive, they're highly protected. You don't get to be a part of them unless you... States are different in how it works, but it's a complex process, and it's meant to establish cause to lead to an indictment. So they brought in Tim Parlatore, and he is a lawyer, so he was able to sit there and hear these questions and say, this is ridiculous. How are you dare asking me this 48 times? And it's not just the fact that they asked the questions, but listen.
After 48 times, including Mr. Parlatore telling the prosecutor at times, what you're doing is unethical, you need to stop. She said, well, if your client is so cooperative, why won't he just waive his privilege?
Insane.
Now, that's kind of a nice political point or a layman's point, but for lawyers and for people that worked in the Department of Justice, they know that is flat out unethical.
Yeah, it's basically the same thing as if you're innocent, why don't you just testify? It's the same thing. Or you invoked your right to remain silent? Well, how come if you're so innocent, just talk? Right, that's sanctionable conduct for a prosecutor. This is a close cousin to that. Well, why doesn't your client just come in? Or why don't you just waive it? Why doesn't he waive it? Why doesn't he testify? It is total corruption from prosecutors who know better, and they're still cheating. I mean, they're cheaters and they're bullies. That's their entire existence. That's why they look the way they do. But it is reprehensible for them to do it, and they did it to another lawyer, which shows that bravado they've got.
That the idea that you would try to draw a negative inference from a legitimate invocation of counsel is an outrageous moment, and that's just one that we had
48 times
visibility into. Secondly, I would point to Jack Smith's near obsession with having a, quote, speedy trial in the January 6th case.
Even though he waited years.
The speedy trial right is derived historically from a defendant who is incarcerated, who has the Pyrrhic victory of going to trial a year or two later and being acquitted. And the question, of course, becomes, what do I do with that free time I just served for a year or two? That's why we have a constitutional and a statutory speedy trial right. And it is invoked by defendants or waived by defendants every day in federal court. What you don't see every day in federal court is a federal prosecutor for a non-incarcerated defendant insisting on having a speedy trial, when the Department of Justice, in fact, has its own guidelines to avoid charging decisions and trials on the eve of elections. Instead,
not for Trump, though.
We had Jack Smith pushing with all his might, pushing the Supreme Court to expedite a hearing that was still in front of the D.C. Court of Appeals, and only angrily losing that battle, apparently, when the Supreme Court took up the question of immunity. The third thing that I would point out from my summary is something that came from a respected lawyer in Washington who represented Walt Nauta, which is viewed as kind of the keys to the kingdom in their investigation into President Trump, a person that they were intent on flipping at all costs and eventually charged. And this lawyer was the subject of an extortionate ploy. I have no other way to phrase it than that. He was brought in very early into his representation to the Department of Justice, where he met with Jay Bratt and about 5 or 6 other prosecutors in the room. Mr. Bratt had a folder open that appeared to be information not about Mr. Nauta, but about Mr. Woodward, the lawyer. And he looked at this, according to Mr. Woodward, and said, I see that you have a pending application for judgeship with President Biden. I don't take you to be a Trump lawyer. I would hate to see you blow it. You need to flip Walt Nauta against President Trump. That sequence of events, which has not been fully investigated to my knowledge or fully litigated, but has been presented and has been publicized, is a devastating indictment of the willingness of a Department of Justice attorney with others around him to engage in essentially extortion or bribery or whatever you want to call it, or obstruction. The enforcers of obstruction, in fact, were willing to obstruct justice because of an ends justify the means mentality. So that brings me to just talk for a couple of minutes about what I think the cost of lawfare is and really why I'm here, which is not for any sort of personal gain or political moment for me. Lawfare, in its form with the Department of Justice in criminal cases, is an effort to manipulate law as a way of targeting an individual who's despised by the user. Justice and the concept of rule of law rely on honest cops and principled prosecutors to follow evidence and to make impartial determinations as to accountability. It is evidence-driven, not animus-driven, and that's why I'm here.
So James Trusty lays it all out, 3 different problems with Jack Smith, and they are all big, calls it actually extortion, and he's a prosecutor. So he knows some about that criminal statute because he's charged people under it. So now let's wrap this segment up with Senator Kennedy slamming Michael Cohen and this entire saga, calling Cohen a rat in another case, of course, in New York. Here's
right now,
Kennedy.
Senate Judiciary Committee member and former attorney himself, Senator John Kennedy. Senator, good morning to you. What do you make of what they're doing on some of the other channels where they recreate what was going on in inside the courtroom.
Yeah.
Well, first, Steve, where's Kilmeade today?
He's in Washington. You guys have switched places.
Well, Lawrence and I were speculating that he's really out getting hair plugs, but I don't want to start a rumor.
Joe Biden is the only person that I know actually had hair plugs.
Let me answer your question. Here's my impression. I don't know Mr. Cohen.
Yep.
I followed him. I suspect he doesn't get invited to too many parties.
No.
He reminds me a lot of Michael Avenatti, sort of a grifter type. I'm not saying Mr. Cohen has never done the right thing, but if he did, it was because he was probably constantly supervised and cornered like a rat.
Okay, so there's Kennedy. So talking about all these people and how corrupt they are, going after the president. Good testimony in both houses. We've got the Senate with Kennedy having some comments on this, and then, of course, Congress hearing from James Trusty. So will Congress do anything about this? Are they going to defund Jack Smith? Are they going to send another nasty letter? We will continue to cover it, my friends. So thank you for joining and subscribing to our channel as we do, wherever it is you're watching this. We'd love to have you back here. So thanks for hitting that subscribe button, liking this video wherever you're watching this, inviting a friend or family member to come over and join us. We'll see you back here on the next one.